I'm Judge Bright. I'm sitting this morning with Judge Cradle and Judge Bishop on the matter of the State of Connecticut versus Anthony Small. Docket number is AC 43660. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. I'm going to ask everybody to introduce themselves just so we can make sure we can hear and see each other okay. I'll start with the judges, then the appellant, then counsel for the state. Again, I'm Judge Bright.
I'm Judge Cradle.
And I'm Judge Bishop.
Anthony Small, pro se.
Good morning, Your Honors. For the record, Michelle LaFont for the state.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. And if you get disconnected for whatever reason, please log back on through the link that was provided. We'll suspend the argument until we know that we have everyone present. I'm going to ask everyone when they're not speaking to keep their microphone muted so that we can avoid any background noise and any feedback. The judges are going to do the same. And if we have questions, we're going to raise our hands and ask Mr. Small or counsel to call on us again so we can avoid the background noise. But if you don't, we'll just ask the question as we would in the courtroom. Each side has 20 minutes to argue. I will keep the time and I will hold up signs at 2 minutes, at 1 minute, and when your time is up. And the appellant can reserve time for rebuttal. I would ask that at all times everyone keep their cameras on so that we can make sure everyone is present and fully engaged. So with that, I think we're ready to begin. And Mr. Small, are you ready to go?
Yes, I'd like to reserve 5 minutes for rebuttal.
Okay, you're all set. You can proceed.
Good morning, Your Honors. Good morning to the appellee. I believe this situation is key on the issue of parole eligibility, the General Statutes 54-125, as defined by Holmquist versus Manchin, where a person convicted of a crime and sentenced, his nearest opportunity of release is at 20 years plus 5 years of his good time to satisfy the maximum minimum of the statute of 25 years. I was sentenced as a parole eligible inmate, and I was given 45 years structured around parole eligibility. At appellant's brief A22, lines 9 through 17, the worth of the crime was explained by the late Honorable Judge Ford. And when I mention his name, I do so with great respect and empathy, as I know he has passed away. He explained to me he wasn't giving me 60 years because I didn't fire the gun. And he also explained that he had taken in consideration that I had been doing some self-developing on my own during the 4 years that I had the life without parole sentence. And he stated that I should be trying to work myself towards life and rehabilitation and work my way out. At page appellant brief A21, the sentencing court also explained that I would give up the middle part of my life on the pending imposed sentence. Now, the appellee's brief at pages 10, 11, 12, and 13, they admit, and I don't know unless this court rules that this is true, that my sentencing judge had no authorization to impose a parole eligible sentence. But nevertheless, the legal sentence hearing court, as well as the appellee, the denying me an illegal sentence decision is hinged upon the language that the sentencing court used at A23. When he stated, I'm not going to worry about when you get out on parole, that's up to parole, that's up to the Department of Correction. I don't sentence based on how much time I want you to do, I'm just going to give you what it's worth. That language doesn't negate my claim that a statute provides a punishment for a person convicted of a crime does not deprive me of my life and liberty. The United States precedent in Weems versus United States, Gall versus United States, as well as Matthews versus Aldridge, I have a 14th and 5th Amendment constitutional right, as well as Article 1st, Section 8 of the Connecticut Constitution, to sufficient procedural due process. My due process was violated. I've been incarcerated 27 years. The Department of Correction gave me a parole eligible schedule. I extensively rehabilitated myself. And then after I was submitted for parole, I was rejected. The parole liaison stated, appellate's brief A26 and 76, she's read the transcripts, but she can't give me a parole opportunity based on I'm not parole eligible by law. Now, the language that the sentencing court used when it stated, I'm not going to worry about when you get out on parole, that language was addressed by Marrero versus Warden. And it's a federal case, and it's recognized by state Supreme Court case Breton versus Commissioner of Correction. It says the precise time at when one becomes eligible for parole is not a part of sentencing, but it is implicit in terms of sentencing, and parole eligibility is a function of the imposed sentence. Furthermore, the statute of General Statutes 54-125, parole eligible under Holmquist versus Manson, is different than the General Statutes 54-125A, non-parole eligibility, because you would do day for day under a non-parole eligible sentence 25 years to satisfy your maximum minimum. Whereas in a parole eligible sentence, you do 20 years plus 5 years of your good time to satisfy your maximum minimum. So even the maximum minimums are different. And the sentencing judge has a right during sentencing analysis to take that in consideration, the maximum minimum of my nearest opportunity of release. That has now changed. My imposed sentence didn't impose a punishment on me of non-parole eligibility. I had a right for my sentencing judge when he structured my sentencing around punishment, deterrence, re-entry, and release to get back into society, as appellate's brief A22 and A23 shows. He told me I was smart enough to work my way out of the sentence 2 different times and get back into society and develop myself. But the imposing of my sentence didn't stop with 45 years. What the court actually imposed was a 45-year no probation sentence, with the opinion that he thought I learned my lesson at that point. And if I didn't, I would be back as night follows day. I'm 58 years old. 7 years ago, I would have been eligible for my opportunity at parole release. Now, I'm 58 years old. I don't have this opportunity. So once my sentence was disturbed under State versus Barza, that's an illegal modification of my sentence, because that's not what my judge imposed. Now, if he doesn't have the authorization of jurisdiction, then I need to be resentenced, and I'm still going to be at a negative because Honorable Judge Ford, I had a sentencing relationship with him. He structured my sentence that I would be able to get back into the community and develop myself. The Department of Corrections at appellate's brief A83 and A92 has already endorsed me as a candidate for reintegration back into society based upon the rehabilitation work I've done. I've exceeded expectations in community service, charitable events, programming, and education. The only thing that hasn't been realized in my imposed sentence was the parole eligibility. So the misinformation that I've relied upon is not just any information, it's the general statute that prescribes punishment for my sentence. And it's been a misunderstanding as to the law. And I have a constitutional right to have the judge rely on the right general statutes when imposing and structuring my sentence. I even argued to the hearing court that the sentence was genius if I was able to have it effective, because I did my time, I took his direction, I took advantage of everything the Department of Corrections had to offer. I've been rehabilitated, I'm remorseful, I have respect, even today, for the victims' spirits, the victims' families, and my family. But I don't even know what to tell my family now. I don't even know what to tell my wife and kids, because they've supported me for over a quarter of a century. And now it's like, well, what do you mean you don't have a parole opportunity? So I'm before the court, I'm before the state. In U.S. versus White, it says even the government has a responsibility to ensure the integrity and the fairness of the proceedings. Now, in no way am I here as a layman, as I'm smarter than anybody that I'm before. I'm humbled, I'm respectful, and I'm thankful for this opportunity. But I believe the law is clear. Parole eligibility is a function of my imposed sentence. And if that function was unauthorized, imposed, then I think I need to be resentenced by law before a judge who knows the right general statutes to sentence me under, that my arguing for less, my lawyers arguing for less, is done in a meaningful time, in a meaningful manner, and it's sufficient procedures that I have a due process right to have. I don't have nowhere else to turn. I have numerous judicial mentors, and I even have a conflict of interest in trying to argue this, because I don't want to come off as I'm being any type of bothersome to the court or to the state, because I'm representing myself pro se, and I believe under 51-296A, this is a direct appeal of my sentencing. I've never appealed this before. So an indigent inmate is covered for counsel to have an appeal of his sentencing proceedings, especially when it involves the general statutes. So I believe that I should have been appointed counsel, and I didn't have an Anders brief, or I didn't have any type of hearing as I was told that I would have had a hearing. Appendix brief A, 114 and 115, Honorable Judge Devlin, I know he was being called to the appellate court, but at the time he had told me he would bring me back for a hearing. When I came back, I wasn't before Honorable Judge Devlin anymore. So he even had advised me to file my requests and my waiver of fees, and then we'll discuss counsel at a hearing, as I believe, as a layman, that the evidence I presented in my brief, the evidence I presented at the hearing, in my reply brief, it is debatable amongst jurors. My claim is not frivolous. As the state has admitted, I can't be sentenced to a parole eligible sentence, and the record shows I was. So I'm just stating here today that I need some relief, and I'm at the mercy of the court. I'm at the mercy of the state. I can't work my way out this sentence. And my sentence is intertwined with punishment, rehabilitation, and reentry. I'd like to save the rest of my time for rebuttal.
All right, thank you very much, Mr. Small, and you are in no way being a bother to us in making your argument or taking your appeal. You'll have an additional 3.5, so you'll have 8.5 minutes for your rebuttal.
Thank you.
Okay. Attorney Luke Bond, are you ready to proceed?
Yes, Your Honor. Good morning, Your Honors. Good morning, Mr. Small. May it please the court. I'm Assistant State's Attorney Michelle LaFon. I'm with the Appellate Bureau of the Office of the Chief State's Attorney, and I represent the state. With regard to Mr. Small's first issue, parole eligibility was not a function of his sentence, as made clear by the sentencing court in articulating, I do not sentence based on how much time I want him to do. Secondly, the trial court did sentence him based on the correct statute. The correct statute was a function of the jury's determination that Mr. Small was guilty of 2 counts of felony murder. And as a result, being based on that conviction, Mr. Small was not eligible for parole, and parole was not a condition of his sentence or a basis of his sentence. So the trial court properly concluded that the sentence is not illegal because the sentencing court did not materially rely on inaccurate information. With regard to the Cassiano claim, first I'd like to respond to a statement in the defendant's reply brief. On page 11 of his brief, he says, quote, "The defendant believed this claim would be reviewed without opposition as the appellee opted out of opposing this claim." And he cites to a July 3rd, 2019 transcript at page 3. That July 3rd, 2019 hearing had nothing to do with trial counsel. It was his motion for articulation with regard to the application for waivers of fees and costs and for the appointment of counsel for appeal. So that hearing pertained only to appointment of counsel for appeal. And at that hearing, the state declined to be heard. So the state did not waive its opposition to any claim regarding the Cassiano proceeding at the trial level. Also, to clarify, with regard to the trial court's representation pertaining to a hearing with regard to appointment of counsel, again, that occurred at the end of the proceeding, the hearing on the motion to correct, and pertained to the appointment of appellate counsel. And after, yes, Judge Bright.
So, Attorney Lupon, I want to, with respect to the counsel issue, I want to talk about this case and compare it to Francis and what the Supreme Court said in Francis. So, in Francis, and this is at 322 Connecticut at page 267, the Supreme Court said, "We therefore conclude that when an indigent defendant requests the counsel be appointed to represent him in connection with the filing of a motion to correct an illegal sentence, the trial court must grant that request for the purpose of determining whether a sound basis exists for the motion." Was counsel appointed to Mr. Small to conduct that review?
Technically, I do not think counsel was appointed. I was not able to find anything in the record to show an express appointment. And the first page of the letter that is in the defendant's appendix says that this was the practice and procedure in Bridgeport, and the trial court's remarks at the Cassiano hearing also suggest that even if a defendant did not yet officially request the appointment of counsel, that the Cassiano review was automatically afforded to a defendant filing a motion to correct an illegal sentence.
Okay, so then the court says in a footnote to the sentence I just read, footnote 11, we emphasize that upon appointment, counsel must fully satisfy all applicable professional obligations to the defendant. So, and one of the things which the Francis court says has to happen is a consultation with the defendant. Was there a consultation between counsel here and Mr. Small?
I do not know that based on the record that is currently before me. What I do know, however, is consistent with that footnote, Attorney Bruckman did in fact act as an advocate as required by Francis in assessing the merits of Mr. Small's motion to correct the illegal sentence. And in fact, in the reply brief, the defendant makes reference to the fact that the public defender discussed issues other than the issues that he intended to raise. That suggests to me that Attorney Bruckman did exactly what he was supposed to do, consistent with Anders, which was to look beyond the claims that a defendant has identified to ascertain from the record as a whole whether there is a basis. And I just want to make one point, which is that the state is not entitled to and should not be privy to any of the public defender's analysis with regard to this claim. So I'm going based on the first page of the letter that was sent to Mr. Small, which is included as an appendix. And the presumption is that the defense counsel, the public defender, did in fact do what it was he was required to do. And from what I can see on that first page of the letter, that is in fact what Attorney Bruckman did. He fulfilled his obligation in the sense of being an advocate. Judge Bright or Judge Cradle?
Well, if I could just ask one more follow-up question before Judge Cradle. So in Francis, the court also said that the counsel must then inform the court and the defendant of the reasons for its conclusion. Did counsel inform the court of the reasons for its conclusion?
From the record in front of me, that is unclear. Again, I only have the first page, and it's only appropriate for me to have the first page of that document. I do not know if the subsequent pages of that document contain a certification to the trial court or something else saying that, in fact, this is going to be shared with the trial court.
Didn't Judge Devlin say in the transcript that he did not see the letter and it wasn't appropriate for him to see the letter because it was attorney-client privilege?
My reading of that sentence, Your Honor, I don't want to know about that. My initial reading of that sentence was that it was consistent with Andrews. It would not be appropriate to put that fully on the record. However,
well, wait a minute. He didn't say I'm not putting it on the record.
No,
he said
I
I
know.
don't want to know about that.
Right. I don't want to know about that. Then, Your Honors, I agree that there was not perfect compliance with Francis, but in this case, as in Francis, the Supreme Court noted that oftentimes the merits of a claim, or whether there's a sound basis for a claim, would be apparent on the face of the motion to correct itself. And I believe it was in State versus Yates, this court determined that the fact that there was nothing on the record to show that, that I believe it was that the trial court had been provided with the analysis, that did not rise to the level of reversible error because the trial court did have before it the motion to correct and was able, based on the face of the motion, to ascertain independently that there was no sound basis for that. And in the Cassiano hearing, again, although not entirely clear, it looked like the trial court was prepared to go forward on the defendant's motion to correct at that point in time, and was deferring to whether the defendant was prepared. So based on a presumption that a trial court knows the law, and we know the trial court was aware of Francis, and that the trial court conducts itself consistent with the law, it is reasonable to presume that the trial court was able to conduct its own independent analysis based on what it had before it. And I absolutely agree, Your Honors. What is missing from the transcript is the trial court making an express statement of saying, and I have reviewed this, and I agree with the public defender's assessment.
Judge Cradle had a question.
I did. Judge Bright addressed my question, but now I have a different question. Let's just say we disagree with you and the court should have followed, we believe the court should have followed a different procedure. Then what's the proper remedy?
I don't want to say it would exalt form over substance to have a remand for the trial court to make an express determination as to whether it agreed or disagreed with the public defender's assessment. However, in Yates, because it is apparent from the face of the motion, presumably the trial court, consistent with Francis, did make its own independent determination. And what the trial court had before it was the face of the motion in which the defendant did actually quote the trial court verbatim, the sentencing court, in which the sentencing court said, but I'm not going to be sentence you based on when you're eligible for parole. And the first exhibit 1 was a sentencing transcript, which was not voluminous, and exhibit 2 was the May 3rd, 2018 inmate request form, in which the Department of Corrections said you're not eligible for parole because you were convicted of felony murder. And the defendant's request for relief on page 4 of his motion to correct was for the trial court to give him a different sentence, refashion the sentence. So assuming that the trial court had that motion before it at the time of the Castellano hearing, it was apparent on its face, no sound basis. Yes, Judge Bishop? I'm sorry, Judge Bishop, I can't hear you.
I apologize, I was muted. You can hear me now, can't you?
Yes, thank you, Your Honor.
Do you think it's a reasonable reading of the sentencing transcript before Judge Sarsfield Ford that it's at least ambiguous as to whether or not he believed that Mr. Small might be eligible for parole, but just didn't know what his eligibility date would be? It seems to me that you could read that transcript to infer that Judge Ford thought that Mr. Small was likely going to be eligible for parole at some point, but he wasn't going to opine about when he would be actually released from custody, because that, as he expressed, that's really up to the Commissioner of Corrections. But isn't there that ambiguity in the sentencing transcript?
Even if ambiguous, Your Honor, the question before the trial court here was whether there was material reliance on inaccurate information. So that when the sentencing court expressly said that it does not sentence based on how much time I want the defendant to do, I'm going to give him the time that it's worth, meaning that reflects that the trial court, the sentencing court based its decision as to what type of sentence or the length of the sentence based on the nature of the crime and the nature of the defendant, not on parole eligibility, particularly because a little earlier in that transcript, the sentencing court noted that parole eligibility is variable and can change when statutes change, so that any ambiguity with regard to exactly how much parole eligibility might exist did not factor into the sentencing court's imposition of the sentence. Yes, Judge Bright.
Do you know if Attorney Bruckman or Judge Devlin had before them the case of King versus Hoke out of the Second Circuit?
I do not know that. I do not know what's in the past page 1.
Are you familiar with King versus Hoke?
It's right now, it is not ringing any bells. I'm usually better with facts than names.
All right, so King versus Hoke involved a case out of the state of New York where the sentencing judge thought the defendant was parole eligible and gave him a sentence based on his misunderstanding of the defendant's parole eligibility. The defendant then filed a habeas petition in federal court, in which the district court rejected as being successive. The Second Circuit, in an opinion written by Judge Newman, reversed and found that the reliance on an incorrect parole eligibility date violated the petitioner's due process rights. The court further found that this court has stated that for a sentence to be unconstitutional, actual reliance on the erroneous information need not necessarily be shown. We set it in McGee versus United States, we set aside a sentence after concluding that the sentencing judge's reliance on an improper factor was, quote, quite probable, end quote. So I guess my question is, when it comes to the appointment of counsel and whether Mr. Small should have had counsel to pursue this on the merits, wouldn't the existence of a case like King versus Hoke, as I've just described it to you, impact that decision? And wouldn't it be important to know whether Attorney Bruckman and Attorney Devlin were aware of that case in deciding that this claim did not even warrant the appointment of counsel?
May I ask you a question, Judge Bright?
Sure.
The statute at issue in the Second Circuit case, did it allow for parole eligibility? As I was listening, I did not hear.
It was very similar to this case where
Okay.
when the judge sentenced the defendant, he was presuming the existence of parole eligibility, but the statute had been repealed at the time of sentence, much like it appears to have happened with Judge Ford. So when the court gave the sentence, there was an indication, although not a certainty, that the court believed that the defendant was parole eligible. The respondent argued in that case that the petitioner had failed to show for certain that the judge had relied on parole eligibility, and the Second Circuit said certainty was not required. Now, there are some other differences with the case, but my only point is, it would seem to me that where you have a Second Circuit case that deals with a very similar issue, that case law should have been brought to the attention of Judge Devlin when he was deciding whether Mr. Small was entitled to counsel.
Yes, that would be germane to the assessment, Your Honor, with regard to whether there was a sound basis for it. And the only thing I could say is if, in fact, Attorney Bruckman did discuss that and did distinguish that case based on what the sentencing court clearly articulated in disavowing reliance on parole eligibility, that would definitely change the assessment. And the case that you were discussing with me, it certainly, to me, reminded me of the Morero case and what our case has said with regard to Breton, pertaining to what's implicit in a sentence, and what's implicit is different than what is made explicit, so that any implicit understanding with regard to parole eligibility being part of a sentence, that implicit understanding is negated when we have, as here, a sentencing court explicitly saying that there was no parole eligibility. But I know I'm arguing blind, Your Honor, but
yeah, no. I think you have 2 minutes left, by the way. I think those are fair arguments, but that would be on the merits of whether the motion should be decided. And once we get to fair arguments about whether the motion should be granted or not, it seems like at that point, counsel should be appointed if it's an issue of fair debate, as Mr. Small claims.
Right, unless, of course, as I said, if that was addressed in the letter, I guess it depends then, is it an abuse of discretion for a trial court in agreeing no sound basis exists? Is an abuse of discretion to follow, let's say, controlling law within our jurisdiction, because the Second Circuit does not always control our state law. So then the question would become, was it an abuse of discretion for a trial court to follow state law and not defer to federal law? And I don't know the answer to that, Your Honor.
Well, which is why it's good for someone in Mr. Small's position to have an attorney arguing as to whether this is an issue of federal due process, because obviously the New York case came out of New York State Court as well. So.
Right, and Your Honor, all I can say is, the presumption is that Attorney Bruckman did what he was supposed to do. The letter certainly suggests to me that Attorney Bruckman did look painstakingly through the record and did look at even potential claims that Mr. Small had not identified. So he did the job he was supposed to do. And again, the presumption is that that Judge Devlin did as well. And based on Yates, the imperfection of the record does not lead to reversible error. That is my argument based on blinders and not a full record. Thank you, Your Honors. If there are no further questions, the state respectfully requests that this court uphold the trial court's denial of the motion to correct an illegal sentence. Thank you.
I see no further questions. So, Mr. Small, you'll have 8 minutes and 30 seconds for a rebuttal if you need it.
Thank you. Can you hear me?
Yes.
I just first would like to address, with respect, Attorney Luke Bond's argument about the letter. As I argued at Appendix Appellate Brief 108, I thought the letter was attorney-client privilege. And although the court seemed to know what the letter stated anyway, I still put on the record that I thought that would be attorney-client privilege because that's how I received the letter. But I also briefed in my appellate brief as well as my reply brief I didn't consider that Attorney Bruckman followed the rules of Francis, Cassiano, as far as filing an amicus curiae brief, because he never met with me. He never asked me what my claims would be. I filed a formal motion for a legal sentence. And once I went before Honorable Judge Devlin and I argued what my claims were, then the letter he sent me had no bearing upon the claims that I wanted to present, as well as the harm I suffered. It's still debatable whether or not my due process procedural rights have been violated. And concerning the argument that when Judge Forrest states, I'm not going to worry about when he makes parole, that's up to the Department of Corrections, that's up to the parole board, I'm just going to give him the time I think is worth. The word worth is not defined at that point on why he's giving me 45 years. But the record is clear, because as I briefed and as I put in my appendix at A21, Judge Ford had already told me how much time I was going to do, because he was sympathetic, and I'll be honest and candid with the court. When Honorable Judge Ford sentenced me to life without parole, I was acting a fool and I was ranting, and I didn't deserve the courtesy he gave me when I came back, other than I was more humbled after being a lifer for 4 years and being around people I knew I wasn't a part of. And I learned that I needed to figure out a way to survive in a lifer's sentence. So I started trying to teach inmates how to read. And he considered that on appendix page 22, he stated specifically, first, I'm not giving him 60 years. He didn't shoot anyone. Secondly, I'm considering that he's been in this situation 4 years and he was developing towards rehabilitating himself on his own. And that's what he should be trying to do. I'm not going to praise him for it, but he should be trying to work his way out. That was the first time he said that. So I already knew the middle part of my life, because he asked me my age at appendix page 821. How old are you? I said, I'm 34 now. I was 30 when this all started. So he knew I've been in jail 4 years. He told me you're going to give it the middle part of your life, but then my expression kind of dropped. So he stated on the record, I'm not here to make you feel bad. The legislation lesson that was spoken about Honorable Judge Ford never told me they would change parole responsibilities. What he did was he gave me a legislation lesson on A22, appendix 22, lines 9 through 27. He spoke how actually they were letting people go home for a cold. So he said, you're smart enough to work your way out. That was the second time he told me that. And you have to take advantage of everything and get back into society. So he was just assuring me that I could get back into society after giving up the middle part of my life. I'm 58 years old. I planned to pay my debt to society. For my nearest opportunity at release is under the general statutes of Homequest versus Mansion. Again, that's doing 20 years plus 5 years of good time. That is the word for my sentence. Although the appellee states that, well, you convicted of felony murder, I understand that now if this court rules that Judge Ford doesn't have the authority, Honorable Judge Ford doesn't have the authority to impose a parole eligible sentence. As a layman, I don't even know what's going on. I have numerous mentors telling me one thing. I have the Department of Correction who accepted the parole eligible sentence and prepared me for parole and endorsed me. In 2017, I received my first endorsement, A83 and A92. I received my second one, that I'm ready for reintegration back into society. That was after I did 23 years. I didn't submit at 20 years because I was taking a self-mastery course, which I submitted before the court in my rehabilitation file. It's 93 pages. So even the Department of Corrections, which is a separate entity from the Board of Pardon and Parole, they work together, but they're separate. The Board of Pardon and Parole, they caught the error. And they put in appendix A26 and A76 that we read the transcripts. He did refer to your parole eligibility. Now, there was a question, respectfully, from my understanding, there was a question asked about whether or not he thought or knew. He definitely, under his understanding, knew I was parole eligible, because the last thing he said at my sentencing hearing was that they'll let you know your exact times that you'll be eligible for parole. So there was no misunderstanding that he knew I was eligible for parole. That's the last thing he told me on page 16 of my sentencing transcripts of February 24th, 98. And that's in my appendix. And I believe that would be appendix page A24. So he definitely thought I was parole eligible. He told me I'll give up the middle part of my life. That coincided with my 30s and 40s and being released at my nearest opportunity of release in my early 50s. Now I'm here today as a layman, and the case law of Morrell versus Warden specifically states, Honorable Judge Ford was correct because he veered into the percentages, and that's not a part of sentence. That's why I said the precise time when I would make parole. That's what he's talking about. He's not talking about the fact that he sentenced me as a parole eligible inmate. That's a general statute misunderstanding of law. It can't be separated. Parole eligibility is a function of the imposed sentence. And Durant versus United States versus Ross states that only an unusual prisoner would think that he's not being punished when he's denied parole eligibility. That's not a punishment that was imposed when I received my sentence. I definitely needed counsel. Thank you, Your Honor. I definitely needed counsel to be appointed. Attorney Bruckman, with all respect to him, he did not meet with me. He did not even try to find any claims that would be meritable. And I think today, as I listened to the discussion, this is a debatable issue, and I needed an attorney to represent me. I thank you for my time and consideration in this matter. I caught COVID-19. I was scared to death that I would die in here. And I just believe that this is an injustice and a legal breakdown of my procedural due process rights. And I deserve to be sentenced by a judge knowing the statutory provisions. Thank you.
All right, thank you, Mr. Small. Thank you, Attorney Lukban. We will take the matter under advisement, and we will stand in recess until 10:30 a.m. in the physical courtroom. Have a good day.
Thank you.